And before you begin your testimony, if you could introduce yourself and the organization that you represent. Again, 3 minutes for your testimony, and welcome to the Committee on Judiciary. Jordan, you may begin.
Thank you, Madam Chair, and members of the committee for having me here tonight. My name is Jordan Day. I'm the Interim Director for the Rhode Island League of Cities and Towns. We had been working with Senator Miller and the House sponsor, Representative Slater, over the past few years to make sure that local control and oversight was maintained. And that way, local communities would still be able to have their say in whether or not they felt that, as a policy, they were able to engage on this topic. Regardless of that, we looked at the provisions that would help communities best sustain if they opted into this program. So we looked at the bill, and we're actually very pleased with the provisions that are outlined under local control. And as I spoke with Senator Miller earlier this week, we're happy to see what's been included thus far. There are a few things that we would like to see changed or added in order just to continue the aspect of maintaining some local control and oversight. One of the first things is that we believe that this is an authority that doesn't need to go to the ballot referendum or to a vote by voters. We think that this is something that respective city councils or town councils should be able to opt in and out of through council ordinance or resolution. With the way the bill is written now, we are happier to see that this would be during a general election, so it would be a budgeted cost. But there is still the idea that cities and towns should be able to have that say on their own. Additionally, we are comfortable with the 3% sales tax going to cities and towns where the sale occurs. However, as we all see, there are lots of issues that bleed from community to community. So what happens in Pawtucket can lead into Providence, which can lead into Cranston. What happens in Bristol and Warren can happen in Barrington. And so making sure that communities have some access to funds like temporary impact fees that's in Article 11 of the governor's budget would be something that our cities and towns would benefit from in order to be able to respond to public safety issues or any necessary modifications to traffic congestion, anything that they may need to deal with. The last thing is on that 3% sales tax. The proposal right now is that that would be paid out quarterly, which is consistent with Rhode Island motor vehicle tax payout. But we would like to see it move to monthly, which is similar with Massachusetts state law. And so that way the consistency would continue with Massachusetts. With that, I have no further testimony. You've received a detailed written statement from me. So if you have any questions, I'm available to answer them.
Thank you. And for the public's information, we do read all the written testimony that comes in. I know not everybody can make these hearings, so we encourage written testimony. So thank you for submitting that. Any questions or comments from committee members? Seeing none at this time, thank you for joining us, Ms. Day. Next, Ms. Tanner.
Thank you very much. Good evening, Chair and members of the committee. My name is Liz Tanner, and I am the Director of the Department of Business Regulation. I have with me Matt Santacross, who is the Chief of the Cannabis Regulatory Office. On behalf of the department, I'd like to thank you for the opportunity to comment on this important legislation, and I'd like to applaud Senator Miller, Leader McCaffrey, and the Senate staff for their very hard work on this issue. Thanks to their efforts, Rhode Island is closer to legalizing adult-use marijuana than ever before, and we are honored to have the chance to share our perspective today. As you know, DBR's Office of Cannabis Regulation is chiefly responsible for oversight of the state's medical marijuana and industrial hemp programs, and the primary entity in the executive branch responsible for coordinating and executing policy and programmatic objectives related to cannabis in Rhode Island. On the whole, this legislation before you today is in alignment with Governor McKee's budget article legalization proposal in several important respects. In particular, the proposals share a focus on 4 items. First, equity in licensing and reinvestment of revenue. Second, recognizing the strength and sufficiency of our existing cultivation capacity by extending the current moratorium on new cultivation licenses. Third, the role of local government in setting the rules of the road. And finally, the expungement of past marijuana possession convictions. Additionally, the legislation before you sets out a rational and competitive tax and fee structure that well positions Rhode Island's market relative to neighboring states. We would, however, highlight several concerns with this legislation in its current form, which, left unaddressed, may significantly complicate the expedient realization of a robust and well-regulated adult-use marijuana regime in Rhode Island. Note that our submitted written testimony explores each of these in more detail. We present 3 issues. First, The administrative structure contemplated in this legislation is complex and raises concerns related to separation of powers. In this bill, the Commission would absorb the vast majority of licensing, regulatory, and enforcement duties currently residing with the Department of Business Regulation, the Department of Environmental Management, and the Rhode Island Department of Health. A new advisory board would advise the Commission on social equity licensing and programmatic investment while also functioning as a stakeholder engagement vehicle. Further, the DBR Cannabis Office would support the Commission and the Advisory Board in carrying out their statutory and regulatory duties. Now, while there may be a good deal of merit to this governance approach, we would urge re-examination of this structure with an eye towards removing duplicative functions and reporting lines. Claire Richards, Governor McKee's Executive Counsel, has submitted to you additional comments related to the separation of powers concerns. Second, the transitionary period contemplated in the legislation has timing concerns and should be streamlined. This current legislation requires DBR to issue transitional regulations during the month of September to facilitate retail sales beginning October 1st at existing compassion centers. This is a sensible goal. The existing licensed compassion centers are well situated to begin adult use sales in safe and compliant fashion in the near term. Indeed, the governor's budget article proposes a similar fast-track on-ramp for these licensees. However, the mechanism proposed for transitional regulations raises concerns related to both timeliness and governmental transparency. The statute ought to lay out a streamlined, practical series of discrete steps required for DBR to issue these hybrid permits rather than fast-tracking quasi-regulations. Third, the specificity of certain aspects of this legislation will likely constrain this and future commissions. For example, many of the provisions in this legislation amount to policy decisions that ought to be afforded to the Cannabis Control Commission through its statutory authority to promulgate rules and regulations setting the rules of the road in Rhode Island's adult use cannabis market. A statutory approach that outlines at a high level the public policy goals and intent of the General Assembly through a framework of priorities relating to these important areas of cannabis regulation would then empower the Commission, its leadership, and staff to lay out the finer details of regulation through the administrative process, thereby aligning the industry and market precisely with the Commission's view of these issues. In summary, without question, momentum and progress towards legalization of adult use marijuana continues to build in Rhode Island. And as stated in the preceding remarks, there exists a large degree of consensus on a large number of important components of this issue. And just as importantly, on an approach that emphasizes public health, public safety, and a vital and competitive industry for Rhode Island's businesses and consumers. We sincerely thank the committee for the opportunity to present our concerns today, and we stand ready to participate in any future discussions on this or related legislation, and we'd be grateful for the opportunity to do so. And with that, we'll take any questions you may have of us.
Thank you. Any questions or comments from committee members? Seeing none at this time, thank you. Did you want to make comments, Matt?
I think the director covered it.
Very good. Thank you so much. Next up is John Simmons. Carol Formica. You may approach the table when I call your name. Jeremy Costa. And Stephen Alves. I'm sorry?
Steve just submitted written testimony.
Written testimony only? Okay, thank you so much. So we have Carol, we have Jeremy, and Rep. Jackhart, would you like to approach? Okay, Ms. Formica, we'll begin with you. Reminder, 3 minutes, please, if you could. And if you could please state what organization you're representing.
I'm representing myself as a citizen and an educator.
Thank you. You may begin.
Good evening, and thank you for this opportunity. My name is Carol Formica, and I'm here tonight again as a concerned citizen and as an educator. I have served on the 2017 Special Legislative Study Commission, which was charged to compile a report on all the effects of marijuana legalization, and I emphasize all the effects. But unfortunately, and under strange circumstances, it was suspended and terminated before my colleagues and I were able to present our side of the issue regarding societal impacts. I have researched the effects of marijuana legalization for over 10 years and have shared my research with the public in form of letters, commentaries, and testimonies. I will not repeat all of those findings tonight. Instead, I am here to ask all of you a question. Why would you vote to pass this legislation? What good will come from this legislation? I have been told revenue is not a motivation, as there is no money to be made. Yet, number one, according to the National Institute on Drug Abuse, 1 in 6 children who try marijuana become addicted. 2, in 2019, a Target 12 investigation revealed an uptick of marijuana vaporizers being used within Rhode Island schools, and that in a 4-month period during that school year, 4 tollgate students were taken away in a rescue after having an adverse reaction to the drug. Several medical incidents were also reported by Coventry, West Warwick, and Barrington. Number 3, in July 2021, the Providence Journal published an article regarding a national study that found that young adults who use marijuana were more likely to think about and make plans to kill themselves. In the report, Dr. Nora Valco, director of the National Institute on Drug Abuse, stated that consumption of marijuana increases your risk of suicidal behaviors. Number 4, we are currently coming out of a pandemic that has exacerbated the mental health crisis our youth are facing, with the number of children seeking psychiatric care in hospital ERs skyrocketing. So I ask you again, why would you vote for this legislation? Voting for this legislation would essentially make you all an accomplice to putting drugs in the hands of our children and our students. Is that what you want your legacy to be? Is this legislation in the best interest for the health and well-being of Rhode Island's communities, neighborhoods, and families? Please consider our children and our youth when this legislation comes to a vote, because they are going to be the ones who will pay the highest price and will be affected the most if this legislation comes to pass.
Thank you very much for your testimony and for your service in the past. Any questions or comments from committee members? Seeing none at this time, we'll move now to Jeremy Costa. If you could also state who you're representing.
Yes,
If the button is up, very good.
there we
We're
go.
all set.
Very good. Yes, my name is, again, Jeremy Costa. I represent myself as a citizen, but also an organization called Bike Life Lives Matter. And I have, I think this is progress coming from, seeing this bill develop over the course of 8 to 10 years. But I think there should be major amendments made to this bill. 2430 needs to be reviewed. I don't see any equity in any form. So members of the Senate, I believe that, just last December, the U.S. House of Representatives passed a legislation bill that was packed with social equity provisions, including a grant program that would help states and cities, municipalities, develop equitable cannabis license programs. But I don't see anything tangibly in that bill. I just see a bunch of fluff. I see that there's a equity opportunity for $1 million fund to maybe get back $4 million. But I don't see anything, any provisions. Members of the Senate, I am also one who was formerly incarcerated by marijuana, and Rhode Island needs to help those that have been formerly incarcerated, low-income minorities, and those help start a business in marijuana. But there's only disenfranchisements in that bill. They also, like Los Angeles previously, who has set aside effectively new marijuana license dispensaries for those that were, predominantly poor minority individuals, and allowed those that were maybe formerly incarcerated, have gone to prison for selling pot. They actually helped them and to establish themselves in the community. And that needs to happen, and that needs to be somewhere within that bill. You cannot come out with this first come, first serve philosophy. That is going to do nothing besides oppress the people that are already been oppressed. So going into this manner, having 9 licenses is, a slap in the face again to the constituents and also those that have been deeply affected. Again, I think that this bill, on the outside, it looks good. The expungement rule, I think that automatically expungement should take place. We shouldn't have to go to the BCI to pay a fee or no fee at all. It doesn't matter. We shouldn't have to be burdened again by the court system, any type of municipality, any AG's office. There should just be automatic expungement. So the bill, on the outside, it looks like a lot of fluff. It looks beautiful. And I hope that, we can come to terms, but there should be major amendments made to the bill. I also think that, the commission, it being very small, I think those people that have been directly affected should be a part of this commission. They should be a part of the board in the rulemaking. They shouldn't be disenfranchised or removed from the table. They should be sitting at the table, making the rules and making the guidelines for the access to this new industry. And I will rest my testimony if you have any questions.
Thank you very much. Any questions or comments from committee members? Seeing none at this time, thank you for your testimony.
Thank you.
Next.
Thank you, Madam Chair. I represent Greenleaf Compassion Center. It's
Could you
located
state
on the
your name
Quidnick
too,
Island.
please?
I'm sorry?
Could you please state your name
Sure.
also for the
Sure.
record?
Robert Jackard. I represent Greenleaf Compassion Center. Greenleaf is located on the Quidnick Island. And we are in favor of this bill by Senator Miller. We applaud Senator Miller for his work on the bill. And we are in agreement with all of the philosophical issues in the bill. We have submitted written testimony asking for that the committee carefully consider some technical amendments. And I just want to state to the committee that all of the technical amendments we're asking the committee to consider have to do with the competitiveness and the viability of the compassion centers. And also, we did raise one issue of potential public safety in our written testimony. And I'll be happy to answer any questions.
Thank you very much. Yes, Senator Lombardi.
Just a comment. I want to welcome my former colleague and my working partner in Cranston, Representative Jackard, to the committee. It's always great to see you, Bob.
Thanks, Senator.
Thank you, Senator. Any other questions or comments? Seeing none at this time, thank you for your testimony. Next up, we have Armin Lucy. Do we have Armin? Yes. Karen Ballou. And Peter Kasabian? Kasabian. I'm sorry. Just another reminder, 3 minutes for your testimony, please. We'll begin with Armin. If you could state your name and who you represent, we'd appreciate it.
Yes, I will, Chair. My name is Armand Lucy. I represent the Rhode Island Cultivator Industry Association. Chair Coyne, members of the Judiciary Committee, I am president of the Rhode Island Cultivator Industry Association and owner of Evergreen Gardens, a licensed medical marijuana cultivator. I want to thank the chair and members of the committee and the leadership for holding this hearing in a timely manner. I'm privileged to come before you with the support of a majority of the cultivators, representing all levels of current license classes. There's much to like about the bill, but we think a few changes will improve it. We strongly oppose a sentence in the section entitled Multiple Licenses Restricted. And the sentence reads as follows: nothing in this chapter shall be construed to prohibit one person from investing in multiple licensed entities under this chapter. We feel that that could be very devastating when people could come in and not be a licensee, but could control things through an investment in many different licenses, including retail, cultivator, compassion center. A person's defined in law as an individual or a corporate body. So when you say nothing prohibits a person, that means any entity at all. We're also thankful for the inclusion of a cultivator moratorium. We request that the 2-year moratorium would commence upon the opening of the first social equity retail store, rather than upon the final issuance of the Commission's rules and regulations. The cultivators have had a difficult time over the last 5 years with 3 compassion centers as our only buyers. So until we have other retail stores other than the compassion centers, we respectfully ask for this change. Regarding the transitional regulations proposed, we request that Rhode Island DBR, Department of Business Regulation, be granted full authority to promulgate and approve regulations in order to allow retail sales to begin October 1. Of course, that's just the hybrid license. That would just be through the compassion centers. The way the bill is worded now, you have the commission has to approve these transitional regs. If a commission is informed by October, then we wait. And we've been waiting for 5 years. In closing, I want to thank the Senate for bringing this bill up with the intent of passing this. We look forward to working with the General Assembly and the new Cannabis Control Commission in creating a marketplace that is safe and equitable. Thank you, Chair.
Thank you for your comments.
Yeah.
Any questions of committee members? Seeing none at this time, thank you. Next, Karen, if you could state your name and the organization you represent, please.
My name is Karen Ballou. I'm the owner of Cultivating RI. We are a Class A medical facility. Cultivating RI was the 5th company to be awarded a license in the state. However, today there are over 65 licensed businesses that are cultivating in the state of Rhode Island, and collectively we are all employing over 700 people. I'm testifying today to support the bill. We as business owners think this is a good bill. But unfortunately, Rhode Island industry is in a little bit of a trouble. We are seeing a rapid decline in patients renewing their cards or applying for new ones. Not only are we seeing the medical market shrink, we are seeing the legal market going into Massachusetts. DBR has started posting numbers on their website monthly with activity of sales and patient cards, and it's very clear that the market is moving into Massachusetts along with the legal market that should be staying in Rhode Island. I do have some data and that I'd like to. Sales this November and December and January versus last were down 1.1 million. Sales from cultivator to compassion center. We are down 6.25 million in overall sales. Those sales are moving over to Massachusetts. I'm urging you to pass the bill as swiftly as possible, and also to consider transitional regulations. Back in 2017, we had emergency regulations for cultivators, and it worked out perfectly. We had no issues with it, and cultivators came on board born January 1st of 2017. So with that being said, it's a great bill, and we'd just like to see transitional regulations stay in the bill.
Thank you for your testimony. Any questions or comments by committee members? Thank you. Seeing none, Peter, you're next. If you could state your name and the organization you represent.
I am Peter Kasabian from Loud. Loud is a state-licensed medical marijuana cultivator located in Warwick, Rhode Island. I am before you tonight to express support of Senate Bill S-2430. We need transitional regulations that will allow sales of recreational marijuana to go into effect immediately. We cannot wait until October 1st. Cultivator sales in general are down dramatically, and in some cases 100% to $0 in sales. I made 2 sales in November of 2021 and 1 sale in December of 2021 at my business. Loud has not made any sales in the first quarter of 2022. Many, if not all, of my fellow cultivators are in the same exact position as me. You can imagine how challenging it is to operate a small business and maintain employee jobs, pay rents, property taxes, and insurance and utility bills, etc., with 3 potential customers and a first quarter with 0 sales. A majority of Rhode Islanders are getting their cannabis from adult use retail stores. in bordering cities and towns in Massachusetts. We need this bill voted on and approved expeditiously to save our cannabis industry here in Rhode Island. We need adult use sales to begin immediately with the 3 existing compassion centers. We cannot wait until October 1st for adult sales to begin. We won't make it that far. Again, I appreciate and support Senate Bill S-2430. Thank you for your time tonight.
Thank you for your testimony. Any questions or comments by committee members? Seeing none at this time, thank you all for your testimony this
Chair
evening.
Coyne, could I use my last minute to read the members that are supporting this testimony?
If you could just give that to the clerk, please, we'd appreciate it.
Okay.
The next group up is Jeff Padua, Javon Sobrinto Wheeler, and Stephen Brown. Again, if you could state your name, the organization you're from, and a reminder you have 3 minutes. Jeff Padua, please, you may begin.
Madam Chair, my name is Jeff Padua. I represent a group called the Sensible Cultivators for Intelligent Reform. It's comprised of 8 of the top cultivators in our state. Shall I continue? So we thank the committee, thank the chair. I also like to thank Senator Miller for his hard work, not only this year, but in prior years. We strongly support this bill. It cannot happen fast enough. Medical marijuana sales in Rhode Island are dropping. People are going to Massachusetts. Each of my clients has invested hundreds of thousands of dollars. They've employed dozens of people, and that has been at risk because of the supply-demand dynamics in our state. We particularly like the moratorium of 2 years. Of course, we would prefer a longer window so that the cultivators could recover from the losses that they've incurred. And we also appreciate the transitional regulations, October 1st. If there's any way that could be done faster, that would certainly be appreciated. I have provided written comments on some technical amendments. And again, we ask for quick passage. Thank you.
Thank you very much for your testimony. Any questions or comments from committee members? Seeing none at this time, thank you. We'll move now to Javon. If you could state your name, please, and who you represent.
Thank you. My name is Jeevan Sobrino Wheeler. I'm with the Progressive Governance Director with the Working Families Party here in Rhode Island. The Working Families Party supports this bill. We do hope the final version of it has state-initiated automatic expungement language in it. Where it's great to see legalization moving forward of cannabis. We know criminalizing cannabis has disproportionately impacted working class residents, black and brown residents in Rhode Island. It's also diverted funding that could be going towards education, towards affordable housing, towards job training programs, to policing and incarceration. But at the same time that we're legalizing cannabis, we also need to make sure that we're addressing the impact that past cannabis offenses have on residents, and that they'll continue to have even after legalization unless the legislature does something about it. A cannabis offense record jeopardizes a person's chance to gain employment. It jeopardizes the chances for housing in some circumstances. And once cannabis is legalized, we need to make sure after cannabis is legalized, after it's generating profits, generating tax revenue for the state, that Rhode Island residents aren't still dealing with the stigma of a cannabis record for something that's now legal. The expungement also needs to be state initiated, and it needs to be automatic rather than through an individual petition process, which is what's currently in the legislation. And that's important both from a justice standpoint, that everyone who is eligible for expungement for something that's now legal gets it. It's also important from a cost savings perspective and a time savings perspective. It's much quicker and cheaper to do automatic expungement that's initiated by the state, setting up a process all at once, than to deal with thousands of individual petitions from residents. In states that have done the individual petition process, which is what's currently in the legislation, less than 10% of residents who are eligible for expungement end up getting it. And that's because they may not know they're eligible for expungement. They may not have access to legal expertise to help apply for it. It's much more likely to get expungement that relief that they're entitled to through a process that's initiated by the state. 11 states that have legalized cannabis have done state-initiated automatic expungement, so we know the best practices that are already available. And that includes setting up an online portal where folks can go in and check that their past offense has been expunged, but it doesn't require notifying everyone who had a past offense that their record has been expunged. And in fact, there's real privacy concerns with mailing out, for instance, expungement records to people all over the state. If it's to the wrong address, if it's delivered to the wrong place, there are privacy concerns with that. So it's much easier for folks to be able to just go in online and to check. And Rhode Island has an online portal for other expungement purposes right now, where residents can go on it and check, and adding cannabis to that would not be a heavy lift. And to just conclude,
finish up.
Great. Yeah, we're very excited about this legislation, and we hope that it includes a state-initiated automatic expungement provision so that we can more fully celebrate it. Thank you.
Thank you. Any questions or comments from committee members? Thank you so much. Next, Stephen Brown.
Thank you, Stephen Brown from the ACLU of Rhode Island again. The ACLU was an early supporter of the medical marijuana law. We supported the decriminalization law, and we're very pleased to get to this point of legalization. We commend Senator Miller for all the effort he's put into this issue over the years. This is obviously a very complex piece of legislation. We've submitted written testimony that's really preliminary. We plan to submit more detailed testimony, but there are three particular points that have not been raised at all that I just want to very briefly address. One has to do with criminal record checks. I testified on that earlier bill. This one, we believe, has some very confusing and conflicting provisions regarding the use of criminal record checks. We think those conflicts need to be addressed, and just as importantly, as I explained in testifying on the earlier bill, it's really important not to bar people from this employment, especially people who have been convicted in the past of drug offenses. One of the ideas is to provide rehabilitation to these individuals for having served time or been convicted of a crime that we're now saying is no longer a crime, and it would be unfortunate if the law actually barred individuals from participating in this industry. Secondly, we have concerns about employment discrimination. We handled a lawsuit under the medical marijuana law where an individual, job applicant, was hired for a job and then fired immediately after the employer learned that they were a medical marijuana patient. We think it's important that there be strong protections in place. Yes, employers need to be able to address issues of intoxication in the workplace, but they should not be controlling their employees 24/7. And we're very concerned. The bill as it's drafted certainly is not what we would have drafted, but it clearly is a compromise, and we're very concerned to hear that employers want even more power to be able to deny employment to individuals or fire them for conduct that does not, in fact, directly affect the workplace. And we hope that the committee will not weaken that portion of the law anymore. And then finally, a third issue that I just want to address that's not in the bill at all, but it is addressed in more recent laws that have been passed in Connecticut and New York. Massachusetts has addressed the issue through court decisions. It has to do with the power of police to search automobiles based on the odor of marijuana in a car. Connecticut and New York have passed laws saying that that cannot serve as the sole basis for conducting an intrusive search of a car. Massachusetts courts have made the same decision constitutionally. We would urge that this bill address that issue right up front. Take the language from New York or Connecticut to ban that sort of activity. Otherwise, we expect, unfortunately, lots of litigation to get to the question of whether that serves as probable cause to search a car once marijuana has been legalized. So those are a few of the issues we hope you'll look into further. As I said, we'll be submitting more detailed information. I'll be glad to answer any questions.
Thank you for your testimony. Any questions or comments from committee members? Seeing none at this time, thank you all for your testimony. Next up, we have Steve DeToy. I don't see him, but Sherry Cruz. Do we have Sherry Cruz? Oh, very good. Jordan Goyette. and Alan Krinsky. When I call on you, if you could please state your name, the organization you represent, and just a reminder, it's 3 minutes for your testimony. If you have addition to say, you may submit written testimony. Sherry.
My name is Cherie Cruz, and part of the Yes We Cannabis Coalition. So we need to seriously address this more wrong and add more equitable language to any legalization bill. We're in support of legalization, but again, adding more language. And among the key measures that should be included in any legalization bill are the ones that provide for state-initiated automatic expungement and sealing of cannabis-related criminal records to as many people who have been most harmed by past criminalization, especially since we are allowing an elite few to undertake the same activities, but on an even grander scale. It's well known that having a criminal record is used to discriminate against impacted individuals in housing and employment, which the majority of these barriers are initiated right here at this State House. We know that unemployment rates of people with past felonies is 5 times higher than the general public. And as of right now, there are several states that have state-initiated automatic expungement laws for certain cannabis offenses and cultivation. Although New Jersey and Illinois allow state-initiated automatic expungement for not only specified possession cases, but also includes some distribution, manufacture, and delivery offenses. Also recently, as many heard, the New York Cannabis Control Board voted unanimously to allow the first couple hundred licenses to go to people with past cannabis convictions. Using other state examples could help make the case for ensuring there's a pathway for more Rhode Islanders to get from under this failed drug policy. Also, many of the people who have been criminalized by this war we serve sentences of probation and parole, which we know Rhode Island is the 4th highest in the country for the proportion of its population on probation and parole. Several states have also addressed the use of medical cannabis while on probation and parole: Michigan, Pennsylvania, and Colorado. And Washington State has addressed this issue in 2014 via their state's DOC. And New York City enacted a municipal policy in 2019 that limits instances in which those on probation can be drug tested for cannabis. I want to go back to New York. They learned from their initial decriminalization efforts that used a petition-based system and found in the first 5 years only 5% of the people eligible received expungement. They learned from this failure and loss of time and money and adjusted and successfully implemented a state-initiated system. Another example, Michigan State used a state-initiated automatic clearance for just general clean state initiatives and were able to clear over 500,000 past records. This equates to economic mobility, housing access, and overall health for our state. I'm just asking why we in Rhode Island cannot learn from other states' past failures and wins and do the right thing for Rhode Islanders and reach deeper to no longer block economic opportunities, especially for those who have paid the ultimate price on this failed war of being locked up and locked out, and as well as their future generations. So thank you.
Thank you, Ms. Cruz. Sorry, thank you, Ms. Cruz. Any questions for Ms. Cruz? Thank you for coming. Mr. Goyette, welcome to the committee.
Thank you, Senator Lombardi and members of the Judiciary Committee. Again, Jordan Goyette, Legislative Director of Reclaim RI, and I'd just like to say we do support this legislation. We really commend the diligent work over the past year that we've been able to do with Chairman Miller, the Rep Slater in the House, and the conversations we've been able to have since this meeting was scheduled in preparation for it with the Speaker, with Jake Basalin from the Senate President's Office, in getting this bill right and ready for prime time. First of all, we do strongly commend the inclusion of 2 of Reclaim's principal requests for this legislation, specifically the creation of the Social Equity Fund, which would provide upfront SITS licenses dedicated to participant applicants who meet the qualifications of a social equity applicant, people who have been disproportionately harmed by the cruel and harmful policy of prohibition and the greater drug war. I'd just like to expound on that, is that under this program, if someone meets that qualification, because I know there's been some back and forth about this, if they meet that qualification of being a social equity applicant, their application is funded through this program. So they automatically get their funding they need to start up. There's no down payment. There's no money they have to put up front. It's good just like that. Just one of the licensing fees from the new hybrid retailers, that $125,000, under this bill, it goes straight into the social equity fund. That can fund right up front 4 of the 6 initial licenses. Secondly, we really strongly commend the inclusion of a dedicated number of licenses set aside for worker-owned cannabis cooperatives. Under this bill, Rhode Island would be the first state in the nation to set aside a dedicated number of licenses for worker-owned cooperatives. These cooperatives, you don't know much about them. They're run democratically by their workers. The profits of the business are shared equally among their workers. They bring those profits back home to their communities and their families. They spend it in their communities. They grow community wealth in their communities, and they build connections within the cities and towns they're in. So therefore, the money generated from these businesses doesn't go to out-of-state corporate investors in weed from New York or California and elsewhere. It stays right here in Rhode Island. And however, we also do join the cause of this bill needing to have a state-initiated automatic expungement system. We've already heard multiple testimonies expounding upon the shortcomings of states that don't have this system, the very negligible effect they have on sealing and clearing records. Like Sherry just said, less than 5%. Whereas meanwhile, states like Illinois and New York that have these automatic systems have been able to seal and clear the records of hundreds and thousands of people. And I really just like the committee to think just think of the economic impact of that alone, and removing barriers to employment for thousands and thousands of people, especially at a time when we greatly need that to happen. So again, we really commend the work that it's taken to get this bill to a point where it matches in both the House and the Senate. We really look forward to working collaboratively with the committee, with the sponsors, and with the leadership in both chambers to get this bill to a product that everybody can, especially us, can strongly mobilize around and get to passage and get to the governor's desk.
Thank you very much for your testimony. Any questions or comments from committee members? Seeing none at this time, I believe we have Alan Krinsky next.
Chair Coyne, members of the committee, my name is Alan Krinsky. I'm a senior fiscal policy analyst with the Economic Progress Institute. And we believe that if we are going to legalize adult recreational use cannabis, that we should do all we can as possible to advance racial and ethnic equity. And that if we do this, then those individuals who have been disproportionately harmed by the decades-long criminalization of cannabis should not be further criminalized for activities that are becoming legal. And this is an economic issue about opportunities for gaining income and building wealth. And so the people who have been harmed the most, they shouldn't face additional hardships, like we heard before about hardships with employment, housing. They should not only not be left out, they should be fully involved to participate at every level, including employment, ownership, even regulation, management, and funding decisions. This bill certainly contains some good provisions, and I recognize the hard work done by the sponsor and others on this bill, but we feel it falls short in a few ways. I'll just highlight only 2 of those. One is the expungement. We've already heard, but I want to point out one thing about the automatic expungement. If you look at the language of the bill, it seems to refer to automatic expungement, but the way I read it is it's talking about if you file the petition, it will automatically be granted. And that's not generally what I think in discussions about this is meant by automatic expungement. Automatic expungement generally means the state-initiated kind of expungement we've heard before that does not require anything on the part of people whose records, and actually not just convictions, but even arrests, even a single arrest can have effects that can last years or decades. So that's one. The other is in terms of the funding. It was good to hear that there will be this sort of $1 million of starting funding for the social assistance fund. I guess I'm looking forward to seeing a fiscal note about this because even though this isn't going to be a kind of revenue generator like the lottery, it will bring in, I don't know, $10, $20 something million a year, and it's unclear to me if none of that money goes towards social equity and social assistance, how much over time, if the amount, the percentage that will go from the fees, the application fees and such, will be adequate for that purpose. I have some additional details in the written testimony, including ideas on alternative methods of taxation, but I won't address that here. I'd be happy to answer any questions.
Thank you very much. Any questions or comments? Seeing none at this time, thank you all for your testimony this evening. Next up, Rick McAuliffe. I don't see him here. Harrison Tuttle. You may approach the table. Mike DeLauro. And Steve Alquist. Good evening. Just a reminder, you can state your name, the organization you represent, and you have 3 minutes for your testimony.
Thank you so much.
To Harrison.
Thank you so much. To the Senate Judiciary Committee, my name is Harrison Tuttle. I am representing Black Lives Matter RI PAC. So BLM RI PAC holds and advocates for social equity in all facets of our society, and this includes a comprehensive legislation on the matter of marijuana legalization. While it is crucial that proponents are being made and revisions of current laws that are being rewritten for the General Assembly, the PAC reemphasizes the need for the cannabis legislation rollout to be carried out in a socially equitable manner. While the current proposal is a step in the right direction, it is not efficiently addressing the long-standing inequities. So when we look at being able to combat the war on drugs and the effect that it had on our communities, it's really important that although this is a foundational piece for passing marijuana, that we really look to hand out licenses and provide equity for people who have been disproportionately impacted by this. So a lot of the members that have testified today has alluded to that. Additionally, the planned mark of granting only 25% of applications for licenses to Black and Brown entrepreneurs is not sufficient enough in forging the equity that we're striving for. So New York plans to prioritize communities most harmed by criminalization of cannabis by reserving the first 100 to 200 retail licenses to individuals and relatives, those who have been convicted by marijuana-related offenses. Now, although I know that we're dealing with a smaller amount, and it's not even 33, now it is with the 9 going to medical and others, it is still time to increase the number of licenses to people who have been directly affected, either individually or directly by their families. And so translating this into Rhode Island's legalization efforts would be pivotal in asserting the commitment to justice and equity for communities disproportionately impacted by past transgressions carried out by our government and relating to drug offenses. And so the legalization of cannabis cannot come without full decriminalization. Therefore, cannabis must be removed from the Rhode Island Controlled Substance Act. Leaving cannabis under the categorization continues the practice of criminalizing and vilifying communities of color, as enforcement disproportionately targets these groups. Most importantly, though, any cannabis policy in Rhode Island must include automatic expungement of marijuana convictions. If, as a state, we're recognizing the fallacies of our past marijuana legislation, we must alleviate how these wrongs impacted our communities, as in Black and Brown communities, by expunging past convictions. Additionally, we must reject a regression in policy in the form of Senate Bill 2371 that places additional employment barriers for those convicted of felony charges from joining the cannabis industry. So we comprehend that introduced legislation is a compromise of decade-long debate here in Rhode Island, but BLM PAC is calling on the General Assembly to center the lived experiences of the most impacted by cannabis prohibition. Therefore, for Rhode Island to have a truly socially just cannabis policy, one, a policy percentage licenses need to be categorized as a social equity, including cooperatives. Two, cannabis must be removed from the Controlled Substance Act, and there must be automatic expungement of convictions as we reject the bill that would deny convicted felons employment of management and medical dispensaries. Thank you.
Thank you very much. And if you have any addition to add, you can certainly submit it with the clerk. Any questions or comments from committee members? Seeing none at this time, thank you. Mike DeLauro, you have 3 minutes.
Thank you, Madam Chair and committee members. I'll try to keep it brief in light of the hour and the written testimony we filed. The Public Defender's Office has submitted sensible decriminalization and legalization legislation for years. When laws like this that do not impact public safety are being considered by this body, we believe that addresses the issue of overcriminalization. Our concerns with the legislation are basically, though, twofold. First off, the expungement provisions that have been mentioned a number of times. These expungement provisions, we believe, are better than other drafts that we have seen, but they still need to be worked on. And I have in mind the testimony of the other folks that have already testified on this issue. I'd ask the committee to keep in mind that depending upon how you set this up, it would be the responsibility of the Public Defender's Office in many cases to bring these motions before the court. I know we're talking about thousands and thousands of cases, at least since the 1970s. I have in mind when this was changed when possession of marijuana was changed in the 70s from a felony to a misdemeanor. So that's a lot of cases. Again, we're happy to work with the stakeholders, with the sponsors to address that. Our concerns are greater, I think, about the amendments that are made to our drunk driving law and to our refusal to submit to a chemical test law. We're concerned that the language contained in these amendments to those two laws would enshrine in Rhode Island law and make presumptively reliable and admissible two novel forensic science applications that have not been reviewed or passed upon by the Rhode Island Supreme Court, thereby presenting issues of first impression. What we do have is a Superior Court decision by Judge Procaccini from about 1.5 years or 2 years ago, finding that DRE evaluations are not reliable. And for those of you who are not familiar with that, DRE allows, the DRE protocol, the Drug Recognition Evaluation Protocol, allows police officers to perform medical tests and thereafter express an opinion on a person's impairment and what class of drug they are under the impairment of, whether it's a stimulant or whatever it might be. So I gave you the citation to Judge Procaccini's decision. I also gave you the decision, citations to a decision from Massachusetts and Maryland that speak to this issue. So we think that that reference to DRE ought not to be in this legislation, and that our that this be a matter for the courts to figure out. Lastly, the reference to saliva. Come to find out that this is also a novel scientific application. The articles refer to it as OF, or oral fluids. Our concern with that is that not just the civil rights implications, but also that there is no test that can speak to the issue of impairment, especially with marijuana. So for those reasons, we support the legislation, have some concerns about the two parts that I mentioned.
Thank you, Mike. Any questions or comments from committee members? Seeing none.
Thank you.
I believe next is Steve Alquist.
Thank you. I have a...
Could you state your name?
Sure. My name is Steve Alquist. I'm testifying by myself.
Thank you.
I am a resident of Providence. My stuff is a little bit different. Jordan Goyette from Reclaim talked about the importance of co-ops and how this would be the first time that we've brought in co-ops in the country into the idea of marijuana legalization. And I just want to talk about the importance of that, but I also think we could do more. Where, like prohibition, when that ended years ago, every state had a chance to sell alcohol in a new and unique way. And some states did it in such a way, like New Hampshire, where they make so much money from the alcohol sales that they don't have a sales tax in New Hampshire, for instance, right? We have a chance here in Rhode Island to do something, I think, as important with co-ops. But co-ops have drawbacks and they have advantages. One of the drawbacks is that they're hard to finance. I would like to see, and I think that as a result, they could take longer to get off the ground and it could be outcompeted by other non-co-op businesses. I would like to see us do more co-ops. I'd like to see us center co-ops in the conversation here, because what happens with that is that it makes families, small businesses that are owned by everyone involved, have more money. It keeps that money here in the state. It keeps that money would be spent in the state. It'll be encourage other businesses. It's a very important way to think about doing it. It's not socializing it, it's the opposite, but it's also could, in a $100 million or more industry, we could make a lot of millionaires out of average everyday people. The other aspect of this is the social equity. ACLU did a report 2 years ago that said black people in Rhode Island are 3 times as likely to be arrested and serve time for marijuana charges. But we're only giving 6 out of 24 licenses as social equity licenses. That's not even the beginning of equity in this case. I've been calling them social equity seems a little bit wrong in that case. A real number would be closer to 75%, right? 3 times as many. So what I'm talking about here is, and then of course auto expungement is another aspect of it. The equity part of this is low. The ability for people who are already rich or invested to make more money is high, but I would like to see that money be distributed more among people who could use that money in establishing a brand new business model here in Rhode Island. That's all I have to say. Thank you.
Thank you for your testimony. Any questions or comments from committee members? Okay, very good. Seeing none. I have 3 more people on my list for testimony this evening. I'll call their names. I did go through the list, and some people were not here at the time. So if after reading these 3 names, I have forgotten your name, please see the clerk. The next 3 are Dominic Passanella, Ariana Cunha, and Tyler Brown. Very good. Just a reminder, if you could state your name, the organization you represent, and again, you have 3 minutes for your testimony. Dominic, you may begin.
Hi, my name is Dominic Passarella. I'm a medical marijuana cultivator in Rhode Island, but I'm speaking just on behalf of myself today. I just want to speak in support of the language, especially with respect to cultivators. I want to thank Senator Miller for his hard work on this. He's listened to a lot of my concerns, and I know a lot of cultivator concerns, and just a lot of stakeholders in general. And I think he's done a really good job at coming up with a reasonable compromise in this bill. I also hope you guys consider keeping the Department of Business Regulation in charge of creating the regulations. They've been very knowledgeable, reasonable, and thoughtful in their regulations, and it's really refreshing. I own a couple of different businesses, and with any either city organization or state organization I've ever had to deal with, they've just been the most willing to actually help businesses and help create an industry. Thank you guys very much for your time. I appreciate it.
Thank you very much for your testimony. Any questions or comments from committee members? Very good. Seeing none at this time. Ariana, you're up next.
Hi, my name is Ariana Cunha, and I live on Lockwood Street in the Edgewood area of Cranston, and my senator is Joshua Miller. I'm 17 years old and testifying on behalf of Sunrise Rhode Island Youth, a statewide high school environmental and social justice organization. I want to start with the good things I have to say about this bill. Thank you to all of the senators that have put their time and effort into this piece of legislation. It is by far time for us to join the rest of our New England neighbors with recreational legalization. For far too long, Black and brown Rhode Islanders have felt the grunt of the crisis of the war on drugs. It is time for that to come to an end, not next year, not the year after after that, but in this legislative cycle. That being said, this bill has major faults that continue the lack of social equality around marijuana. I join fellow social justice organizations in calling for the following. First, a larger percentage of licenses need to be categorized as social equity, including cooperatives. Black and brown Rhode Islanders deserve to have the first chance to apply for licenses to run dispensaries without debilitating upfront costs, including licensing fees. That, when compounded with economic inequality in this state, are nearly impossible for the affected to cover. 2, cannabis must be removed from the Controlled Substances Act. 3, there must be automatic expungement of convictions. It is simply not fair for some Rhode Islanders to continue to feel the grunt of this crisis after legalization. 4, we must oppose Senate Bill 237, as earlier mentioned, that would deny convicted felons employment or management in medical dispensaries. Those most affected by the crisis must reap the benefits of its legalization, especially in the form of jobs. It is by far time for Rhode Island to be forgiving, understanding, and equitable. I also want to ask that you consider making it easier to get medical cards. Rhode Island has one of the smallest lists of qualifications for medical cards that I have ever seen. I ask you to add depression and anxiety, 2 of the biggest reasons people recreationally use marijuana, to list of qualifications for medical cards, as well as following in the footsteps of our neighbors, including New York and Massachusetts, by making it up to doctor discretion for illnesses, diseases, and disorders not listed on the qualification list. I dream of a world where Rhode Island justly and equitably handles the legalization of marijuana. When this bill is discussed, I ask, who are you fighting for? The big corporations that have enough money to monopolize the selling of recreational marijuana, the tax benefits, or the everyday Rhode Islanders that have been affected by the war on drugs? Thank you for your time, and I hope you have a great rest of your night.
If we could have testimony of Tyler Brown.
Thank you, Madam Chair. My name is Tyler Brown. I am here with Reclaim Rhode Island. And, I'm pretty sure I'm the last name on the list, so I will keep this quick and submit my written testimony after this as well. I just wanted to take the time to thank and express my gratitude to Senator Miller and all those who have been involved in drafting this piece of legislation. The willingness to listen to advocate concerns and what we would like to see out of this bill was encouraging from start to finish and has resulted in something that we can get behind and advocate for, especially with the worker-owned cooperatives. That alone is helping to make this one of the most progressive pieces of legalization legislation in the country to date. Also, the protections for union organizing activities in the workplace, and the piece that my comrades from other organizations have spoken to with great detail already is the state-initiated automatic expungement, and I would just like to voice my support for those initiatives as well. So I will close there.
Thank you very much. Any questions or comments from committee members for this witness?